venue that would not put us out that far, but it does look to me like unless we do something different, we don't really fit the June 10th criteria.
I don't have it right at hand, but I don't think if you put it to a referendum vote that you absolutely have to have it on the primary day. You could pick any day and have a referendum vote if that's your choice. I personally have been encouraging a town meeting vote on it because of the complexity of it. That to do it by referendum, it's one up or down vote. I mean, that's simple, but to my opinion, that opens up a big can of worms. And that a town meeting vote where you actually have discussion and then vote on it. And they could do a series of votes on different sections if they wanted to. If they still want to put it up and down, do that at a town meeting. But just because if you miss the June 10th, doesn't mean you can't do it by referendum, I guess is my point. I don't think.
But if it's a warrant, the point is if it's a warrant, then actually Paul is right. There's a couple different options on a warrant. I mean, if you put it on a warrant, you could actually have it town meeting style, and do it, and then do it by secret ballot that way. Or you could still do it, referendum style, but be on a warrant, just like we do when we elect our select persons. You can still put it on and have one up or down vote for the entire day. It's just you have it open in a town meeting forum for the day, to vote, and you have a coinciding schedule of a town meeting with the actual voting hours for the primary election, and you could do it in warrant style.
But I think it also behooves us to have public hearings if that's going to happen.
Well, no, I agree. We'll do the public hearings in May and all of this.
Right.
But again, we're going back to,
Right.
and at this point, I don't care which way you decide to do it. But
Right.
First I think just decide whether we're going to have, whether it even meets referendum or warrant. If you want to do it referendum style, so be it. It'll be whenever we do it, 45 days out, or however. It doesn't have to be 45, 47, 50, whatever. We'll do it sometime before July 1st. That's fine. Or warrant style, and if we do it warrant style on a warrant, then we can do it on the 10th with everything else. And I don't care. Just decide that, and then we can decide on the merits of even putting it up. So just is this a warrant thing or a referendum thing first, and then we can talk about whether the select board should vote to even put it on anything. Or we can discuss the actual ordinance itself.
Well, my take is that we're being encouraged by Betsy, whomever, to do the 45 thing from here, which would predicate it to be a referendum.
My understanding is that it can be on June 10th.
Right.
Okay. But if you want a more detailed analysis, I'm going to have to put you on. I don't know.
If you want to put it out on here, just say.
I'm not saying you should put it up. I'm saying I would have to put you on. You can do what you want, but I have to look into it.
Maybe it's just a suggestion, and it might be warrant further analysis, but it seems to me that you have a petition that came forth that's based on secret written ballot, the referendum process. I don't think you can change the mode of vote for that at this time. You can't change the petition. So now you've got a situation where the procedure that led up to the land use ordinance amendments was not secret written ballot, but a written ballot under regular town meeting warrant. And I see where there's a self-referential that may have caused a problem. An easier fix may simply be, and this goes back to what Attorney Sepchik said earlier, is it seems to me the measures are somewhat competing to one certain degree, really need to be considered on the same date. If you wanted to make sure you dot your I's and cross your T's, if you haven't issued the order that Attorney Sepchik is referring to, issue the order, do the timeline for 45 days. You have to review your last motion, vote, and call a special town meeting within 60 days of today, so you can coincide both the land use ordinance amendments from the planning board as well as the citizen petition initiation. That way, it's a little bit cleaner because we're on the same day. Because otherwise, there's going to be a lot of issues. Even with the petition is voted on the same day when nothing else is voted to. which it actually refers to, that's gonna cause that problem. So,
I will call your attention though, the last sentence of the petition, it talks about other things passed at the same day or something.
The same day or something.
Yeah, I mean, there are gonna be issues, even if it's put on the same day. And I'm not saying it should or shouldn't, I don't know.
Right, to be honest with you, I don't, from a planning board perspective, I'd rather have it somewhat sequentially. If they have theirs on the 10th and we have to wait the 45 or the 48 or however many days we have to wait to get this done, that'll be fine, because then we won't have the contention. It'll be up or down, you know, you won't have two ups on the same day.
What if you have 2 ups on 2 different days?
What? Right, but then if it's up on 2 different days, the second up is gonna get it.
I'm not giving any opinion on that.
We pay you good money to give us
I
opinions.
can't answer everything.
I know, I'm giving you a good
I
money.
just can't.
Some of us are.
proposed on June 10th.
The liquor petition.
Yeah. And school, if we have that, right?
I know. Will they make a deadline? I'm just saying.
Yeah.
This will
It's
not.
gonna be- yeah.
Speaking out of turn, there's huge school board issues, and I think I've been the only one I've seen lately at any of those meetings. I suggest if you care about your town, you start going to those.
Madam Chairman,
Yes.
not to open another big can of worms, so-
Yes, you
Oh, but here it goes.
okay, but if by any chance you decide to vote today on either setting a town meeting date or a referendum date, there are a number of us who would like to be heard on the subject of whether the draft is ready for vote yet, and whether you should accept it today. We'd like to be heard
Yeah.
on that, if you're inclined to be voting today to put it out.
So, let's just do this. I'm assuming that you're asking if the land use ordinance completed document is ready for us to vote to accept. Is that what you're asking, you're stating, Paula?
That's what I'm saying, that if the board is ready to order it to be going out to vote, we'd
Right.
like to be heard on whether it's ready to be put
Okay.
out to vote.
Eric, are you having a nap? Are you okay?
Just, if we want to just kind of have it, just so we can avoid having a lot more votes and stuff, if we want to agree that we're going to do the referendum a different day than the 10th, I'm okay with that. And then if you want to go back and review your previous thing and change the day for that, do what you think you need to do with that too. But if you want to go ahead and just start talking about this and just generally agree that we're going to do it in referendum style, you know, but not on the 10th, or have some kind of a meeting, not on the 10th, and just to move forward with this so we can actually get some business done. Okay, I'm okay with not going on the 10th, if that's okay with you guys.
But the document is here, completed and ready for us to accept
That's
as
what we
completed.
think. So if you want to go ahead and open the discussion of whether or not you should vote on the document, and Paula and others want to chat, have at it.
Discussion?
I'd like to ask Mr. Subcheck if you have looked into the retroactivity clauses in this land use ordinance and what legalities that,
You mean the proposed one?
yes.
Yeah, I've looked at them.
What is your opinion on that?
My opinion is with regard to proposed, let's see, proposed retroactive provisions in the wind power sections, that it wouldn't be, I wouldn't recommend that retroactive provisions be passed, because we have pending litigation between these two parties. And I would also not recommend that the retroactive provision in the petition be passed. For the same reason, we have litigation between these parties. If a retroactive provision is passed, whether in the proposed ordinance or by way of the petition, the danger is you're going to have somebody claiming that they have some vested right, a right that had vested, and then the retroactive provision tries to eliminate that right. And I just think you're going to end up in court again and more. So that's my opinion with regard to the retroactive provisions in the petition and in the wind power sections of the proposed ordinance.
All right, Judge Horton said the answer is for the planning board to go back and fix the Clifton land use ordinance, and that's exactly what the planning board did. We have not asked for a less strict ordinance. We are just asking for the fixed ordinance applied to our part of the permit. We are not asking for a standard change, period. What the Beckford's petition, or Paul or whoever, wants to do is change the standards in the Clifton land use ordinance to a much more strict standard. A standard they know that cannot be met. It was presented to no public hearing, and we've already dealt with that, but we presented our request to the planning board, public hearing, and the planning board had plenty of time to consider the request and hear from the public. If we put before the voters and approve, the Supreme Court will decide whether it is valid or not. And this section of retroactivity will be decided by the Supreme Court. The town doesn't need to be involved with that decision. The town's not getting caught in the crosshairs of this litigation that's going on. In a couple of months, the Supreme Court with 7 judges will hear it, and they will say, you can't use the retroactivity, you can use the retroactivity. So that's where we are. So there is no downside to the town on this part of retroactivity in our request.
I think the downside is that it will get challenged legally, and the Supreme Court, from my understanding, cannot be looking at any new information. And this is new information.
Well, number one, I think it'd be quite disingenuous to accept the petition with the retroactivity provision and then reject what the planning board did when it has retroactivity in it as well. That just doesn't seem fair to me in terms of policy. That seems like policy decision to me. Speaking to vested rights and issues, which is a valid issue to raise, I don't think that's an issue in this case, and I'll tell you why. You've got a situation where retroactivity is a legislative decision that can be made, and it basically overcomes. There's a statute that has a rule of construction; everything applies into the future prospectively. A legislative body can apply retroactive provisions unless it offends the Constitution. There has to be a constitutional right at stake. Now, here, that's not the case. I can assure you it's not the case. If anyone were to cry foul for retroactivity, it would have to be Pisgah Mountain. They're the only ones that could potentially have vested rights with respect to the wind energy facility. Is there anyone else out there in the town of Clifton with a wind energy permit or with a wind energy facility? There are none. So there's no one to affect. The notion that pending litigation somehow stops our legislative process is not the analysis. It's whether or not there is a constitutional right at stake. You mentioned vested rights. There's case law, very clear, where when you have an old property owner, they get a permit, they rely on that permit, they go through expenditures, and they build their project. Maybe it's a hotel project. They build a hotel project. Then they try to change the law to say, well, now you've got to tear it down. No, they've vested their rights. You can't do that to that specific owner. Applies to anyone else in town that hasn't vested those types of rights. So there's nothing wrong with that type of retroactivity provision. It's a legislative policy discussion. And I think what Paul was mentioning was, when it comes to the prospect of the town getting sued or someone getting sued, no one can stop anyone from filing a lawsuit. That's whether the merits of it are they're 100% or 0%. Anyone can file a lawsuit. With respect to the particular retroactivity provisions for wind energy facilities, that will be determined at the Maine Supreme Court level. It's very clear in a very recent case that when the law court, they're changing the law, they must look at that change. It's the McDimmett case that dealt with recording fees. It's crystal clear. That'd be half provided to the town attorney.
Sure.
I would like to mention though that when this retroactivity clause was first presented to the planning board, it was laid out like it happens all the time and it's very legal. I looked it up to see where it was applied to. And I've seen 2 cases in Maine where it was applied in Phillips and in Montville, and the language was identical. The retroactivity clause was in there to go back to the date that the moratorium on wind expired. And the retroactivity clause applied to the entire wind section. This is very different and not comparable to what we're proposing in this land use ordinance. We're taking specific lines and making them retroactive 4 years ago.
And that is because those were done improperly, and everybody knows it. They were done not illegally, but they were misprinted, they were flaws, they were mistakes. The consultant has clearly said that. It was a mistake in the ordinance. I'm not asking for 500 feet from property lines and make that retroactive. I'm just saying, let me have the fairness of the right rules in my permit.
I'm just saying that this will get challenged because this cannot be compared to any other legal retroactive clause that's been proven.
That's not true. That's not true. Not even close. Not even close.
That's all I could find. I'm sure as a lawyer you have much more information at your fingertips. And I'd love to hear a retroactive clause similar in nature to this one that has applied.
It happens all the time. Call the town bar. They do it constantly. They do it almost every.
Like 4 years ago. I mean, I'm talking about a comparable because we have not just a clause governing an entire section or an entire ordinance. We're taking just specific standards that we're applying it to from 4 years ago, and I just don't see anything comparable in those.
It's a legislative process. You may disagree with the policy.
I'm not saying that. I just don't want to see us getting challenged in court.
Unless you're offending the Constitution, then it's legal.
I think Paula had again.
I think we need to be talking in concrete terms here, what we're talking about. What we're talking about here is that in 2010, we enacted low-frequency standards. In court, they did not convince the judge that they could meet those low-frequency standards. Those are the low-frequency standards that now, retroactively, the planning board is saying to the town, well, let's just vote those out, let's take them out, and they're not replacing them with anything.
They were gas.
Excuse me, I haven't finished speaking.
Just let her talk, Paul.
So, unless you can show me somewhere where they have put in a protection against low frequency, I don't know why would you take it out completely? Why would you just say, let's not regulate low frequency anymore? Why would you do that? If he couldn't meet the standard, then change the standard to one he could meet, not do away with it altogether. If what you're looking for is a standard that he can meet, then write one. But be honest about it and bring it to us, saying it was too strict, now we're making it less strict. Don't say, well, we're not going to regulate low frequency anymore.
Okay, Erica has hand up.
First of all, I want to make it clear here that two things. I don't know if this probably should have gotten passed on to everybody. But I wrote this letter because actually the presentation letter to this should have been passed out when we started. I probably should have read it first. But it says, attached, please find the proposed revision of land use ordinance. The board worked hard and diligently on this revision for the past couple of years, but most especially throughout the spring of 2014. Since January, the board met once or more times per week, and members spent extensive hours of personal time researching, updating, and proofreading the revision. Minutes and meeting summaries were posted online, and public comments were addressed in a timely fashion. The results now require your action. Please vote to place the revision on a warrant to be voted upon by secret ballot. We recommend the following language. Should the town of Clifton adopt revisions to the existing land use ordinance duly posted and on display at the Clifton Town Office with an effective date of 1 July 2014. Certain revisions in the ordinance related to wind turbines are proposed to be retroactive. These retroactive revisions remove and correct errors made in the submission requirements initially approved in June 2010. there are no changes proposed for making retroactive any performance requirements. Should these changes become retroactive, the town attorney has indicated there may be litigation issues with affected parties. While the board agrees this is a possible outcome, the board believes and recommends the town leave any litigation up to the affected parties, only providing the barest minimum of response to acknowledge any actions taken against the town in such litigation. Thank you for taking the time to meet regarding this important matter. So I just wanted to memorialize that the planning board was acknowledging the opinion, and there's no big secret here about the fact that Dave didn't like that. So that's the first thing. The second thing is, for the low frequency standards, exhaustive research has indicated that there's basically not an issue, not a provable issue, even from the Australian Medical Association, from New Zealand, from Ontario, and from exhaustive studies done in the United States that correlates directly low frequency to people's problems in a way that you can actually go through and measure and calculate, number one. Number two, the standard that was removed was not a performance standard, it was a submission standard. And you know this was a submission standard because the submission standard was based on coming up with low frequency for gas turbines at 450 feet, which was the limit of the ability to do that particular calculation for the impact of even measuring the distance. So the distance of 450 feet for the gas turbine low frequency issue is being extrapolated out to thousands of feet, which is an incorrect application of the science. So therefore, that submission standard was removed. The other submission standard that was removed was the ISO contours. The ISO contour standard is again something that's a physical impossibility to do, and I'm not even sure exactly where it came from. It did seem like a good idea at the time because when you're doing ground contours, you do ground contours before and show ground contours after before you do a drainage project, but the thing is, sound is a heck of a lot different than ground contours. So thus, that's why it was removed. So those are the two big things. In regard to the earlier, again, false allegation regarding the diluting of the standards, okay, in a nutshell, the standards were actually increased more because we've made a 45 decibel standard at property lines, so that was an increase in the standard. And we again recertified 35 decibels at houses. Now 35 decibels just happens to be probably quieter than your living room. All right, if you're just laying on the couch in your living room without anything on, you probably aren't even hearing 35 decibels. It's rare for you to actually even get under 30 decibels. In 45 decibels, if you go to, the letter that was circulated saying, I don't want to hear a dishwasher in my house or my property. For the record, the Beckford property, the entirety of Beckford property, the emission from the wind turbine project that was currently proposed and approved by the planning board, the maximum emission on the Beckford property is 32 decibels. So in other words, not audible to most people. So the fact that the Beckfords have been saying that they're having a dishwasher on their property is another false public statement. On top of that, if you go to the Lowe's ad for dishwashers, it even says on the Lowe's ad, 45 decibels, virtually silent. So in the public forum, 45 decibels is being advertised by a reputable company that probably most people in this room do business with on a regular basis and trust to provide products for your house and services. They're indicating that 45 decibels is virtually silent using that particular standard. So there's been a lot of what I would consider to be lies, fear, and intimidation delivered to people in this community because some people just don't want it. And the comment was even made early on in the game. I'll do whatever I need to do to protect my family.
The subject of
No,
Paul was next. I was looking
No.
at Eric, and he did not need to yield the floor if he didn't want.
Hold on. Please let me have Paul speak. And I think Teresa, you were even first. I'm sorry.
Okay.
Just
If I can even remember what I was thinking of.
Move on to the next person.
You're going to have to because I just had a brain cramp. It'll come back.
I want to restate what
I
Paula
just
said
remembered.
earlier or communicated was that if the judge said we couldn't pass the low frequency standard then we're asking for a less standard, and that's not true. The standard that was written in the Clifton land use ordinance, that has been changed, was for a gas turbine test. So that's why we're asking for retroactivity to just clean up the ordinance. We're not asking for a less requirement, like she communicated.
So can I point out that it is a standard that we're
Speak
talking
up.
about, it's not a submission requirement. I'll read it to you if you feel the need to hear it.
I don't think it's,
I'd like to speak on the new standard because it got switched. I mean, this felt like a bait and switch. I spent months attending meetings, learning all of the LEQ plus 5 dBA standard of testing. I got it. Friday night, I finally saw the final revision, or not even the final, it was just another revision to the sound standard. Totally different. I had to spend the weekend reading and trying to understand what L90A 10-minute average and this whole WEF on minus WEF off meant. It did not make the standard stricter, it actually loosened it up. And all the comments made so far about a quiet whisper in your bedroom at night is false, based on the new standard. The way it is now being allocated is it's WEF on minus WEF off, and the standard is 35 dBA. Sounds lower than 45 dBA, doesn't it? But we're not looking at the same LEQ versus L90A. This makes the sound much higher. We're actually talking about in a rural area at night, we're looking at 30 dBA ambient sound. Therefore, a wind turbine sound limit would be closer to 65 dBA. If our ambient is 35,
How do you do that now?
if our ambient level is 35,
Okay.
so WEF off is 35, and WEF on is, say, 65. 65 minus 35 would put it under the sound standard.
You don't add it up that way.
But it's a simple subtraction, that's the way the ordinance reads.
Sound-
Okay, then
sounds
tell me
lower.
exactly how it is, because right now it says that 14.8, 8.8, 0.5, 0.4, the WEF only level can then be deduced by logarithmically subtracting the L90 background level from the total L90 measured level with the project running. Is that true? That's what it states.
That is what it states, but you don't understand how you do the math. It isn't, if you have the turbines on, and then you turn them off, turn them on, turn them off, then you get to see what the background ambient sound is. So say at the property line, like Beckford's property line, it's 35. So you turn the turbines on, and it's 36. You know that it's adding 1 dBA, which you can't detect by your ear, at that property line, so it's at 36 during those segments of time. It is more strict than it was, guaranteed.
But that's not how it is, because if you're subtracting it, you're saying 1 decibel increase. That would be great if it was. And that's why I was okay with the LEQ plus 5. Because a 5 decibel increase is easy for people to understand. It's saying, I'm going to take whatever it sounds like and I'm going to add 5 decibels to it. That's actually quite a bit, but it's livable. I could understand it. This is saying WEF on minus WEF off can't exceed 35. That's a 35 decibel increase.
No. It can't exceed 35 total.
Total, but it doesn't read that way. It reads the
But that's what it
equation,
means.
the
Then
logarithmically
Bruce answer that
equation.
question, because he's the one that talked to Dave Hassler and can
Yes.
explain it.
Okay,
100%.
that is a total misunderstanding of sound and
I
science.
really hope so. Can you please explain it to me?
Well, I would have to educate you first in something called logarithms, because what it amounts to, if you add 2 sources of 35 dBA, you get, I think it's, I'm not sure, Mike Smith would know the number, you add 3, so you'd end up with 38. You don't add 35 and 35 and get 70. There's a mathematical calculation that goes on
It
here.
should be in here and easy for people to
It says
understand.
logarithm.
I spent all weekend,
matter.
just because it says logarithm doesn't mean
Well, I'm
anything.
sorry that,
I'm an idiot? Is that what you want to say?
no, I'm sorry that you don't understand the science.
Well,
Okay?
Who does?
All right.
but you and Hessler.
Uh,
I don't even think Eric understands.
No, I do, it's just that Bruce worked on this, and I'm trying to stay focused on,
I have
my
had-
set of issues.
At
I've
another
had
issue-
several people
excuse me.
read this for
Yeah,
hours
me
and come up with the same conclusion. This is saying ambient plus 35.
In
No,
the
it's-
interest of time.
Yes, please, let me have some interest in time. Yes.
In the interest of time, if you're gonna put this out today, have the planning board, have the select board members actually read what's there. If you haven't, I want you to know that there are parts of that draft that are there, unless they changed it. I noticed at 10 o'clock last night, they put out a new draft, which I haven't had time to peruse yet. I spent the last 3 days doing the last one. There are parts that I can point to you which are in violation of state statute. I can point to parts that I would like to, that I would think that the select board should ask Mr. Subject to review. I'm not sure that he has done that yet. There are several parts that I think need, before you put this out to vote, before you recommend it to the town to vote on, that the board needs to understand. And it's a lot there, I can tell you. You know, I've gone to all the meetings and I've tried to keep up with it, but there's so much there and it's changed so many times. You cannot, and I can show you what we did in 2011. You cross out what you're taking out. You put the new in italics. They did not do that. They picked and choose and took it out, and you have to hunt and go back and take the old version and compare every word of the ordinance to find the changes that have been made.
Point of order on
There
that.
will be unintended consequences.
Point of order is, I posted initially all these lined out versions, and I was told it was too confusing to read. Stop doing that. It's easier for me to take the old one and lay down the new one, and that's what Paula said. And she's been the only person coming to these meetings. Now, the first I started to hear about lined out versions again was I heard, got an email via the town office through Stephanie, like Monday, regarding these line outs. Now, for the whole month of April, there was a bunch of lined out, marked up editions right below all the non-marked editions. So they were there for the entire month of April. They didn't disappear until last Friday or Thursday, the lined out versions, because we started to make substantial updates and we're winding down to this week. So I did put all the line versions for 1 week. So basically, for 1 week, there were not line versions. So again, Paula, because she's dragging her feet, she doesn't want this to go through, and she'll do anything, say anything to get here, okay? Because that's where I'm being in the field, being totally unsupported by Paula, because this is like 20 times better than what she put forth for us in 2010. And sorry, Paula, you know what? I try to compliment you, and you did put a lot of work into it in 2010. But this is 10, 20 times what you put together for this select board in Clifton to look at compared to what you looked at. And now you're saying, after all the work I put into it, that you're saying, oh, don't do it, and there's all these violations. You don't even know what they looked
It
at.
just changed last Friday. We didn't have a final copy until last night.
All I'm saying is that if it's being held
It was
up
minimally
because
changed.
it
Article
was
14 was the only one that changed.
Some
And
standards
Article
are,
2.
If
Some
it's being
standards
held
are
up
pretty
by not
technical.
meeting the 45-day deadline, don't hurry it through now until you've got a good idea of its strengths and its weaknesses. That's all I'd ask of you, because put it out right now, we don't care. I think we could defeat it because it has so many problems with it. And once
Yeah,
the
through
voters become
lies,
aware
fear,
of those
intimidation.
problems, they will vote against it. And I'd rather they had an option of voting for something good.
Last comment,
I
Tressa.
think I finally remembered what I was talking about. One thing I want to mention about the quarry discussions that is pretty serious, because they've also got sound issues, and one thing that was mentioned and that the town is considering is that the gas engines don't necessarily put out the low frequencies. You can get the distance, but you can't necessarily get the effects of whatever frequencies are being put out. So that's something that's just that we need to consider. And the other thing is that when someone's passionate, trying to defend their land, their lifestyle, their culture, whatever it is, and you're fighting progress or change or whatever that might be, it is literally everyone's legal right to do what they can to defend themselves. And in many cases, towns currently looking at the east-west corridor are saying, we don't want that coming through here. And they're developing ordinances that would block them, whether it's a speed limit or some kind of building construction on the road or blocking it in some way. They don't want that. And towns have the right to create ordinances to block something from coming through and destroying them. So try to get a balance if you can between protecting and creating things that you're trying to block. Make sure you're really working for the same things. But the citizens have the right to say, I don't want this, and we will create something that can block something. My point is make sure that that's really, really what you want before you jump into that pot of stew.
So citizens in this town, and this is my opinion, are close to 800. Our job as select people is to take a vote on a document that has been produced and given to us tonight. Public comment states it's not perfect, it has faults and fallacies. That's a comment, that's an opinion, as everybody has the right to make an opinion. I need to pull this back and say our job is to vote on whether we accept it and whether we decide to, when we decide to vote. I think we have been encouraged to use the 45-day parameter, to give that time to happen, to have public meetings, to have them do what they need to do, and then the entire citizen body needs to make a decision. And if there are issues with that after, we will deal with that. We can't sit here and do all of this and make everybody happy and produce a perfect document. It's not democracy, it's not where we live, it's not what we're obligated to do. I don't know all the legal ramifications of stuff. I think it's commendable that Stephanie's dissected and done all of this stuff on her own. I don't understand it when I read it.
Well, neither does she.
Well, and that's the part that citizens need to vote on. She's instructed and allowed to have an opinion, as all of us are. My job as chair is to bring this back to the floor. And I think that's where we need to be. So I want to end public discussion at this point, and I would ask the select people to make a motion to vote on the amendments before us.
When did you want to do that? Do you want to make a special meeting, a special town meeting, 45 days from today?
I think 45 days from today is when we would be allowed. Huh?
Yeah, let's look at your schedule, make sure it's not Sunday.
But I did this already. 45 days from today, when we will give this to the town clerk, will be June 23rd, which is 10 days after the 10th of June. So we're 10 days past what would have been our original voting day. That's 45 days. That doesn't mean we need to have it then, but that's a 45-day parameter. And that feels to me like a strong recommendation from MMA attorneys, our ordinance, wherever. Correct me if I'm unclear or wrong in this.
What will happen in 45 days?
That's just a time frame to
That would be the earliest we could have.
have a vote.
Oh, okay. Because you said, I'm going to give it to the clerk, and I just wasn't clear what you meant.
Tonight ours is to we're to accept it.
And you'd have to vote to order the clerk to put it on the ballot.
Right, correct.
Today,
Today.
not in 45 days.
That's right.
Right, that's what I said, yeah, thank you for fixing that.
You understand that,
We'll
right?
put it on a ballot, either a town meeting ballot or,
Referendum,
this negates us doing anything to the 10th, right?
the only opinion I gave was that for a referendum secret ballot,
Right.
the municipal officers have to order the clerk to put it on the ballot at least 45 days in advance.
Correct.
I didn't encourage anything other than tell you that standard.
Correct.
Yeah.
But my concern also is that if we do or hope that it's gonna happen in June 10th, we're gonna get slapped for that. Jess?
So what you're thinking of doing today is putting it to, saying it's okay to go on to vote in 45 days. The select board will vote today to put it on a ballot in 45 days.
That's what I'm asking or thinking.
No, not to put it on a ballot in 45 days. To start the process today, and the earliest the town meeting could be would be in 45 days.
So the town meeting would be the vote.
That would be the vote.
Once that's done, do we have to vote within 60 days? Was that, did I misunderstand?
Yes,
Yeah, we do, we have to
More
have it
than
within
45
60.
and less than 60.
Thank you.
So the town meeting would be, or the town vote would be no sooner than June 25th.
23rd, which is
Time.
Wednesday.
Eric, you did.
The enactment date on the new draft says July 10th, is that right? Was that a
July
typo?
1st.
Was it supposed to be June 10th, or was that a typo?
No, it says July
You
1st.
said July 1st.
Why is that?
Well, because this thing came up last night, I was gonna write June 10th on there because that was the vote. So then because of the, having to have a final copy and the ambiguity last night of when the date would be, but knowing it was gonna be before the end of June, I put July 1st on there so that I didn't have to go reprint it and waste all that paper again. It was just practical. Because I knew last night I wasn't positive it was gonna be on June 10th or not. And so if it wasn't gonna be on June 10th, then it might have been on June 23rd, 24th, 25th, I didn't know. So then I thought, well, this way, if I only have to print it once and kill that only so many trees, so I thought if I put July 1st on it, then no matter when it was in June, it doesn't have to take effect like the instant it gets voted on. It can take effect, on some other day.
But
So
would
that-
that supersede the citizens petition?
Well,
to
no,
be
because the
enacted on that
enactment,
date?
well, no, because if it was on the 10th, okay, it's still the enactment date and the effective date are two different dates. The enactment date is the date it's voted on. The effective date is the date it becomes effective. So, and the citizens petition says the enactment date. So there's no chicanery in that because the enactment and the effective date are two different things.
Okay. Can I have to clarify? So is the intent with putting the header up there of that date to override this section which says that the ordinance becomes effective on the date that it's enacted? And aren't those two in conflict being in the same?
No, because in the ordinance, I changed it to say,
Oh,
or whatever date is effective in Article 1 to preclude you from coming and saying that to me today, because I knew that you would pick up on that, actually, Paula. So I actually knew that. But no, it has nothing to do with petition. I knew that the enactment and the effective date are two different things, okay? Even if it was the effective date was like the 1st of January of 2016, still the enactment date would be the day it gets voted on.
so am I to understand that the drafts that were on the website yesterday are not necessarily exactly the same as the one you have there in print now?
The only thing I changed was that one wording in the sentence this morning on the enactment date in Article 1, before I brought it in here this morning. Because I thought about that when I woke up this morning, I reread through that and wanted to make sure that I crossed my T's and dotted my I's, and I read that paragraph, and I wanted to make sure that that matched up with what I wrote on top. So that was only like 3 words in Article 1. So the effective date is different than the enactment date. But the enactment date does go with yours, but if this happens after the petition, then this one would be senior because it's going to happen afterwards. If it happened the same day, then it's questionable as to which one is senior.
Is the same repeal that you voted on last night, does that repeal of prior ordinances, is that still the same? Did you make any other changes after the meeting last night?
No, we just wrote, just what we did at the meeting last night, the sentence that said that this supersedes previous ordinance.
That's one of the things I'd like Mr. Subject at some point to give the town an opinion on, the repeal of ordinance.
Right, well, that's what you had in there before, Paul. We used the exact same words that you put in there in 2010 that we reaffirmed in 2011. Or we, let's say in 2011 when we voted on it again. So that's what you had the first time, so I left it alone.
Jess has had her hand up just a second. Yeah.
My only concern is that possibly, I don't know if you guys have read it or not, but if you haven't read it, how can you vote on it today? To put it forth to vote.
Good question.
Ask Pelosi that.
Because they're not the approving board.
They're not our
They're not the
selectmen.
board approving it. They can't approve it. That's why they can do it.
It's not saying we approve it, you're just saying that
People
we're
can vote on it.
Just
It's a whole
going
different
to
thing.
allow it to go on the ballot.
I'd like to suggest, if the board is going to move planning board approach amendments through a referendum vote, which it appears that they're going to do, the thing, just to remove any doubt and make sure the process is as clean as it can be, I would like to recommend or suggest that, I know there's already been public hearings involved, but have another public hearing, and so that it meets the schedule, where the schedule needs to be
Yeah.
before the vote occurs, just to make sure the procedure is clear, because you have a situation here where the public hearings occurred before the order. There is provision in section 2528 that requires a public hearing, so I just want to say, let's have another
Well,
public
we're happy to have as many
Yeah.
public hearings as people want, we'll do it every week if
I was
people want.
planning to make that part of my,
Thank you.
And can I just ask that we print at least one copy with showing revisions?
Yeah, we will, as soon as business gets taken care of today, we can go and manage through all that.
Can I just ask clarity as well, because I'm really concerned about the petition piece. I don't, and if we, I mean, and I will tell you, this came to light late yesterday afternoon, that this 45-day thing was a part of what we were doing. So it was not clear if that was going to happen, it was not sure what the legality was behind it, none of that was there. But Dave gave it to me, I mentioned it to Eric on my way out, this is gonna